Hi, I'm Brennan Aberle, one of the attorneys at Aberle and Wall, and this is the second chapter of the free courses that I will dub the Quarantine Chronicles. And as the weeks go by in this dull, pale room, my hair and beard are getting crazier, and so perhaps am I. Actually, speaking of that, let's redo this intro because there is a way I've always wanted to do it. What's up, all you cool cats and kittens? This is the second chapter of the Quarantine Chronicles, and this week I want to talk to you about one of America's favorite pastimes, and that is marijuana. It's a frequent hot button issue, and more so perhaps recently because of the legalization of industrial hemp in a flower form, which we'll explain all of in just a bit. Um, this is kind of my plan for how this session will go. First, I want to talk to you about hemp, what it is, what it looks like. We'll do a little history lesson of how we got to this point. Then we're going to set hemp aside and talk about marijuana and give you kind of a quick summary of where we are in what's the case law on when you can search cars, houses based on odor of marijuana and stuff like that. And then we're going to combine these two topics together and talk about what are some of the interesting new legal issues that arise because marijuana and hemp are almost entirely indistinguishable from one another, except that one is legal and one is not. So it brings a kind of an exciting opportunity to start raising some new legal issues of diminished probable cause and challenging the identification of marijuana, not just for the purposes of its introduction at trial, but also um, for the purposes of the state reaching its burden of beyond a reasonable doubt. So there are a lot of exciting new topics that come up, and we will get into all of that. And then after it's over, we'll take a few minutes to summarize it and talk about why this work is so important right now. So let's dive right into it. All right, so let's take a pop quiz. I'm going to show you these pictures and tell me which one you can tell is hemp and which one is actually marijuana. The answer is that you can't because they both look exactly the same. And there's an even more important answer here, which is that in some ways they are the same. It gets a little bit confusing because of these human made distinctions by using colloquial terms like hemp and marijuana. But there are three scientific names for marijuana plants. It is one genus, cannabis, and three species. You have cannabis sativa, cannabis indica, and cannabis ruderalis. Any of these plants contain the things about marijuana that you're probably mostly familiar with, which is that it contains THC, which is the psychoactive agent that gives you that high. THC stands for tetrahydrocannabinol, and more specifically, it's delta 9 tetrahydrocannabinol. You can pull extract oil from these plants, and that's the type of stuff you're going to put in the brownies and things like that when you hear about people making edible psychoactive foods from marijuana. And any of these marijuana plants can be used to create fibers for rope, paper, on and on and on. Now, what is hemp? Hemp is the same uh, genus and can be the same species of those three plants. The thing about hemp is, as we define it, is hemp is specifically bred. These plants are specifically bred to have a low THC level to get rid of the psychoactive content that is in marijuana. And so that may mean that hemp and marijuana are going to have the same genus and species name. There are subspecies and other taxonomical classifications that we throw in there, but generally these plants are the same. When the THC is bred out to a low level, that could be any level, but federal guidelines have it set at 0.3% THC. When it is below that level, it is widely believed that no matter how much of that you rolled up and smoked, you could not possibly get high from it. And conversely, if you pull the oil out of hemp, what we call CBD, but again, it's the same thing for marijuana or hemp, the CBD oil you could not get high from. So the differences between hemp and marijuana, the main difference for our purposes, for the government's purpose in the way it's classified, is that the THC is bred down to a level that is so low that this plant could no longer be used to get high with. But otherwise, it's essentially the same plant all the way down to having the same scientific name. All right, so now that you know what hemp is, let's talk about the history of why hemp is a big deal in North Carolina right now. And to do so, we need to take a trip through history. So, can we get some effects for taking a trip? Okay, that's good. I want the ripples though. Can we get the time travel ripples? All right. All right. So the year was 20. All right. So the year is 1937, where we will begin our story of how this aggression against hemp, which should not stand man, got started. We're here with our hemp made shirts and this gnarly hemp bracelet that the coolest kids wear. So prior to 1937, there was not a lot of regulation of marijuana and hemp. There's plenty of documentation that marijuana had been used recreationally throughout the world, and plenty of beginnings of laws on the books in the United States and other places. But the United States did not have any type of rigid enforcement of marijuana policy. If you're a conspiracy theorist, 1937 saw the rise of a corporate pushback against the cheapness of using hemp to create paper and cloth and other things with its fibers, and that a media mogul named William Randolph Hearst played a large role in demonizing marijuana and hemp, and did so with the help of a man named Harry Anslinger, who was one of the first government officials who was put in charge of national drug policy. At that time, it was under the Department of Treasury's bureau, but ultimately this would transform itself many years later into all of the drug control agencies that we know today. But Harry Anslinger was a notorious he was pro-prohibition, anti-drugs, and a pretty noted racist who pushed some of this drug policy in order to victimize people of color. More on that later, but no surprise that those issues are woven together and have been for decades and decades and decades. So, the Marijuana Tax Act was passed in 1937 and it effectively criminalized marijuana and hemp because it became something people could no longer engage in any kind of mass use because it became too expensive. So over the next few years, more and more laws were passed criminalizing marijuana on state and federal levels. But actually, the Marijuana Tax Act was lifted in during World War II because there was an effort to have farmers grow hemp again for the war efforts, which is how we got exciting United States Department of Agriculture videos like this one.
Long ago, when these ancient Grecian temples were new, hemp was already old in the service of mankind. For thousands of years even then, this plant had been grown for cordage and coarse cloth in China and elsewhere in the East. For centuries prior to about 1850, all the ships that sailed the western seas were rigged with hempen rope and sails. In 1942, 14,000 acres of fiber hemp were harvested in the United States. The goal for 1943 is 300,000 acres. Thus, hemp, Cannabis sativa, the old standby cordage fiber, is staging a strong comeback.
Indeed. So, where does that take us? All roads lead us to 1969 with noted buzzkill Richard Milhous Nixon, who then championed the Controlled Substances Act, which was an attempt to centralize drug enforcement by taking all of these controlled substances and putting them into different schedules. There were 5 schedules initially, and marijuana was listed as a Schedule 1, which was the highest schedule. Schedules were based on a few factors. One of them, to be in Schedule 1, it has to have no medically accepted use, a high risk of addiction, and it has to be deemed to be unsafe to use even with medical supervision. So that's a pretty high bar. No medical accepted use at all. It was in a category with things like LSD, and whereas cocaine was in a Schedule 2, a lower schedule, because it didn't satisfy all the exact same requirements. So the Controlled Substances Act really sort of sent us forward into close to about the time we are today. Throughout the last several years, there have been these little pilot programs to cultivate hemp that the federal government has allowed the states to do. But for the most part, things remain the same. Now, in 2018, there was a big movement to there have been several movements over the years to try to pull hemp out of the scheduling of narcotics under the Controlled Substances Act, because even though hemp and marijuana are different species of the same plant, the definition in the federal schedule of cannabis products encompassed both of them, and there was no differentiation at all. It was not viewed that THC in marijuana, the psychoactive component of it, and CBD or cannabis oil, the component in hemp, these things were again not viewed as distinguishable. And so in 2018, there was an act that was pushed into Congress. It was the hemp. It was a hemp-related act that did not pass at all, but the language from that got incorporated in the United States Farm Bill of 2018, signed into law in December. I think it was December 20th of 2018, and that law finally redefined what marijuana was in the federal scheduling, and it pulled hemp out of the Controlled Substances Act and allowed states to then open up, with some regulation and supervision, but allowed states to open up agricultural industries for hemp cultivation. All right, so that takes us to North Carolina, and I actually have to back up one more time. So North Carolina has had a very limited agricultural hemp industry under a federal pilot program since 2014 or 15. There was an exception allowed for these little pilot programs. They were very strictly regulated by the USDA, and nothing like the economy around hemp that we have now. When the federal government descheduled this, North Carolina then automatically went into a place where we didn't have many rules on the books for what was legal and what wasn't, and the hemp industry flourished in that. And then, as a result, two very powerful lobbies started to get tension with one another through the North Carolina General Assembly. So, in one corner, we have the North Carolina Farmers and Agricultural Lobby, who understandably have invested a lot of money now in land and time and resources into growing hemp for all of its purposes, whether it's for oils and cloth and things like that, but also for smokable hemp, which, despite its very low THC level, there's an industry for it, and for whatever reason, people smoke it and have reasons for what effects they say it does or doesn't have. And then in the other corner, you've got the law enforcement lobby, who are concerned that they don't have a unified opposition to hemp as a whole, as far as some of these oils and other purposes, but there is a unified opposition to smokable hemp, which is hemp in its flower form that is indistinguishable from marijuana. So the argument there is, if smokable hemp is legal and carried around and people can just claim that's what they've got, we've got no way to field test it to determine if it's marijuana or not, because there's no field test that exists to assess whether this flower has 0.3% THC or less. So as a result, that tension brought us to a place where the House and Senate each separately brought up bills where they legitimized the hemp industry but banned smokable hemp. Then there was a compromise to ban it but push it down the road. And that tension continues today. So there is a lot of uncertainty and doubt about the future of hemp generally, but specifically hemp as it exists in a flower form. So that's sort of the history of it. And before we put hemp aside and talk about marijuana, let's actually take a closer look at some hemp. I went to a store that sells it and got a goodie bag that we will unbox together. So let's take a closer look. So here is the hemp that I went out and purchased. Here is the receipt in case my friends in law enforcement are planning a raid on my law office. This is actually hemp and not marijuana. So let's take a look at two different ways that it is packaged and sold that I purchased it for. This here is hemp in a pre-rolled joint form. So it's 0.65 grams of shake, and we'll pop that open, pull it out. It is rolled just like a marijuana cigarette, as they say, just like a joint. You've got a filter that you could, of course, purchase on your own, rolling papers you can buy, and this is indistinguishable completely from a joint made with marijuana as it is distinguished from hemp. But it smells the same, looks the same. If I were to break this open and pour it out, it would look just like marijuana shake. And then here is it not pre-rolled. This is in what we call the flower form. So this is very similar to what marijuana is going to be like. We've got it in this cool little pill bottle. 3.5 grams of pine berry strain. It is grown in the good old US of A, locally sourced. In fact, I think it is from Asheboro, so very close. And then this is interesting. So this is what we talked about earlier. You'll notice there is a little bit of information that this product is hemp flower grown in America in compliance with Section 7606 of the U.S. Farm Bill. We talked about the Farm Bill just a little bit earlier. And then, of course, this denotes that it is a product that contains less than 0.3% THC. So let's pull some of this green sticky icky out. And as you can see, it's a good bit in there for 3.5 grams. It is completely indistinguishable from regular marijuana. Let's see how close we can get with this camera. You can see those nice orange hairs on there. That's how you know you've got the good stuff. So this is hemp in its flower form. And since I kind of feel like I'm doing a food review video and I've never done one, let's go ahead and throw this in there. I don't know that less than 0.3% THC gives you the munchies, but in case it does, I recommend pairing the pine berry with Little Debbie strawberry shortcake rolls, who are not giving me any money for this shout out. Little Debbie, reasonably priced and reasonably good. I think that is their slogan. So, all right, let's move on. All right, so that brings us back to talking about marijuana for a little bit, and I want to focus on two specific areas of law that are useful for you as a defense practitioner when you're defending your clients who are charged with really any crime where the the encounter with police has begun because of marijuana. So those two categories are, we're going to talk about stops and searches that are based on marijuana, and specifically because it's the most common, are stops and searches that are based on the odor of marijuana. However, it's important to talk about stops and searches that are based on marijuana in plain view, because we're going to come back to that in the final section of the course. I also want to talk to you about how officers identify marijuana for the purposes of it being used either to search someone or charge them with a crime, and even more so, identifying marijuana for the purposes of its introduction at trial against your client. So remember, there's two things we're dealing with here. Pre-trial, we have these lower standards. Does an officer have reasonable suspicion to stop you? Do they have probable cause to search or arrest you? And then at trial, we're talking about, has there been evidence presented that the state can show beyond a reasonable doubt that proves the existence of some fact? And specifically in this case, we're talking about, what does the state have to show to prove that if you're charged with possession of marijuana, that the substance itself is actually marijuana? So we're going to talk about stops and searches. We're going to talk about identification of marijuana. But before I get there, I like to, when I can, stop and throw out some practice points and tips. In any case where marijuana ends up being the reason for the initial encounter between law enforcement and your clients, make sure you're asking tough questions of law enforcement officers when they describe the encounter to you, particularly if you have a case that's in district court instead of superior. You're not going to generally don't have access to discovery, and so it's incumbent upon you to really get into the weeds of asking questions pre-trial or during your investigation phase when you're representing a client, so that you can make sure you can issue spot well. And then, speaking of issue spotting, I save it as one of my tabs for quick websites to go to, but the North Carolina School of Government has a criminal law blog, and if you just type into Google NC School of Government criminal law blog, you'll find it. It's a really easily searchable blog that is maintained by some of the most intelligent professors here in North Carolina on some of these issues, specifically criminal issues around stops, searches, and things like that. And so when case law comes out, when we get new cases that are opinions have been issued by the North Carolina Court of Appeals or North Carolina Supreme Court. A lot of times they'll do updates on the blog, and so make sure you're checking that regularly. That's usually a good place to start. All right, so let's go ahead and start with one of the most common scenarios, which is that your client's car was searched because of the odor of marijuana. I'll spend a little bit of time talking about houses and persons, but the car one is so common, not in the stop itself. Make sure you're asking tough questions about why your client was stopped. It doesn't usually have to do with marijuana, although I've represented plenty of clients where the officer stated they pulled the car over because they smelled marijuana emanating from the car while they were following it. So it will come up in that scenario. But most of the time, your client's pulled over for some traffic violation, speeding, whatever. And make sure you're watching the body worn camera videos and things like that, or dash cam, because sometimes the reasons for the stop are worth challenging. They don't always bear out to what reasoning you're given for why the vehicle was stopped. But let's assume the vehicle is stopped for the purposes of a lawful traffic violation. That gives an officer reasonable suspicion to stop you. And then the officer approaches the car and smells the odor of marijuana. Now, on the basis of odor of marijuana alone, as an officer who can testify that they're trained and familiar with the smell and they recognize that smell of marijuana, can an officer search the car based upon, and its occupants, based upon that odor? Now, the answer to the first question about whether they can search the car based on odor alone, generally in North Carolina, the answer is yes. We'll talk about this again in the final section. But with respect to the second question, can officers perform one of these warrant exception, the automobile exceptions, sometimes called the Carroll Doctrine? Can law enforcement perform a warrantless search on the occupants based on marijuana alone? Is a much more nuanced, has a much more nuanced answer, and there are some very important limitations on that people forget. So let's take a look at two quick cases that will help you kind of focus on the right types of questions to ask law enforcement when you're preparing for a motion to suppress in one of these cases. So the first case we're going to talk about is State v. Melinda, and I'll provide the citation here below. So State v. Melinda is a case where a vehicle was stopped. It had two occupants. There was the defendant, who's actually the passenger, and the driver, who is located in the driver's seat. The passenger defendant, police actually recognized from prior dealings and knew of some criminal history that he'd had. But he is, after the car is stopped, he's taken out of the car, he's set aside on the curb. The officers then approach the driver's side and notice the smell of marijuana in the pocket on the driver's side door. And the marijuana itself, the odor of it can be localized to right next to the driver, who is likely the person who was in possession of it. Now, the officers then search the passenger, who, remember, is outside seated on the curb, and they find cocaine on his person. And the question then became, can the passenger be searched when there is an odor of marijuana coming from the vehicle, but it seems to be localized to one person and not every occupant in the vehicle? And the answer is, you cannot search the other occupants if the odor can be localized to an occupant that is not your client. So that is very case specific, very fact specific, but make sure you're asking as many questions as you can to try to distance your client from where the marijuana is found in a situation where there are multiple occupants, because your client may be able to avail themselves of not being allowed to be searched under this exception to the warrant requirement, under the automobile exception to the warrant requirement, if there's no individualized probable cause to search your client based on the odor of marijuana. So here's a second case that is even more fun. So State v. Pigford was a case where the defendant and a passenger, the defendant in this case is the driver, were stopped in a vehicle at a checkpoint, and a deputy came up to the driver's side window and um, was able to smell the odor of marijuana. The driver was taken out of the car and ultimately searched. There was cocaine residue that was found, among other things, and that defendant was charged. And in that case, the defendant raised this issue, which is if there's an odor of marijuana coming from a car, certainly the car could be searched for under a probable cause theory and warrant exception probable cause theory to look for more marijuana. But can an occupant be searched when the odor of marijuana can't be localized to any occupant at all? So now we can have a car with two or more people. An odor of marijuana is coming from the car, but there's no evidence that the odor of marijuana is coming from any person specifically. Can those people be searched as a part of the warrant exception? And in this case, the court said no. There was no testimony that the deputy couldn't have walked around the other window and seen if the smell of marijuana was just as potent from any particular window in this car. There was no testimony that after the driver defendant stepped out that the officer smelled marijuana specifically on the driver defendant while he was being detained. And so since the odor of marijuana could not be localized to any occupant at all, occupants themselves could not be searched. Now, there's heightened protections that the court leans on in arriving at this opinion. One is that, a car can be searched with an exception to the warrant requirement when there's probable cause due to the fact that there's a reduced expectation of privacy in vehicles that are heavily regulated, among other exigent circumstances about cars. But people are listed specifically in the Fourth Amendment, along with places, homes, and they are afforded a higher expectation of privacy from unreasonable and particularly warrantless searches. And so the Pigford court held that the search of the defendant in that case was impermissible, and thus the evidence should have been excluded. There's some interesting points that they raise later about what would have happened if the state had argued inevitable discovery based on anything that they had found in the car later. But because the issue wasn't raised, the court doesn't reach it. But there are at least two circumstances we know. So from Pigford, if the marijuana cannot be localized to any occupant, even if probable cause may exist to search the car, there isn't necessarily probable cause to search any of the occupants. And then from Melinda, we know that if there are multiple occupants and one occupant is definitely not attributable to the odor of marijuana, that occupant can't be searched. So there are some good limitations on vehicle searches based on odor of marijuana. Just make sure you're getting into that, checking to make sure these cases are still good law, and keeping an eye on those types of issues. So when we talk about searching a person, and this is a vehicle is not connected to this next type of situation, can an officer get probable cause to search someone based on the odor of marijuana coming from them alone? And then more importantly, can an officer then search that person without a warrant? So again, there's a federal circuit split issue, and it certainly is worth you raising because the case law in North Carolina seems to be pretty fact specific. In that there's no clear rule that would fit all factual scenarios. Probably the biggest case on searching a person, a warrantless search of a person based on marijuana in North Carolina, is State v. Yates. And in that case, The court looks at these things as sort of a two-pronged analysis. Is there probable cause? And then is there exigent circumstances to search them without a warrant? And in this case, this defendant had walked past the officer multiple times by himself. The officer recognized the odor of marijuana during these one-on-one interactions, and ultimately the court found that they did have probable cause. The officer had probable cause to detain that individual and search him. Now, could the officer have gotten a warrant? Did the officer need to get a warrant? In this case, the court cited some other authority in North Carolina for the idea that drugs themselves can be easily destroyed. And so as a result, the exigent circumstances likely existed in that scenario to justify a warrantless search of the defendant's person. Again, read these cases specifically, because sometimes you'll see little summaries of them that make them seem like they stand for one proposition. But when you get deeper into the language of these cases, you'll find that a lot of them are kind of fact specific. So, this can easily be turned to a situation where somebody is walking by in a group of people and the officer smells marijuana but can't individualize it to one person. Or maybe there was just one walk by or something like that. There's a lot of ways you could differentiate yourself from that case. So it's helpful to kind of sit down, go through the individual facts of these cases, talk about your case, and see how you can distinguish it. But that's where we are. Now, again, we'll come to this in the end. The question is, a lot of these cases that I've been talking to you about are written in a time when hemp was not walking around able to be smoked by people who were seeking its whatever other medically related reasons or simply recreational reasons than getting a high like marijuana. People believe that smoking hemp does other things, whether it relaxes them or serves some other purpose. So these cases are written in a time before that. We'll come back and readdress some of these issues. So searches of homes are going to have the highest protection that are afforded to citizens, and that comes from homes being very specifically enumerated in the Fourth Amendment warrant, situations where a warrant would be required. The issue becomes, so we've got two issues here. One is, can a house be searched with a warrant? Can you get probable cause based on odor of marijuana alone? I haven't seen any cases that show that exactly. Most cases tend to have multiple additional facts that an officer put forth to a magistrate in order to get a warrant. If you get a case where a warrant was issued on odor alone, that is definitely worth you challenging. With respect to a house, the closest analogy I can think of is there are lots of cases across the country on trash pulls where an officer will search a trash can outside of a home in order to develop probable cause to search. And there are several jurisdictions that held where there was evidence of drug activity on one or two particular occasions that wasn't enough to get probable cause, partly because drugs are fleeting themselves, and somebody having smoked at some point in the past doesn't mean that there's drugs there now. And certainly it would be similar if the odor of marijuana was smelled by a door or near an apartment or a house. At some point that could be a guest who brought that odor in with them, or that marijuana is already gone by the time that odor is discovered. So that is certainly worth taking a look at. Now, a related issue is, well, what if you get a circumstance where we do have a couple of these other tips, but the officers went into the house without a warrant at all? We know that there are only a few specifically delineated exceptions to the warrant requirement. One of them is this exigent circumstances type situation. We've got consent, fleeing, hot pursuit of a fleeing felon, There's some community caretaking function. There are these limited protective sweeps if there's articulable reasoning that somebody might be armed and dangerous in the house. But um, the most common one you hear is that a house got searched when probable cause was developed, but nobody had time. An officer didn't get a warrant. They just went and immediately started searching because of some, quote, exigent circumstance. And those cases are fact specific. In the drugs context, you usually hear about there was some noise upstairs. It sounded like people were maybe going to flush something down the toilet. But if you don't get specific facts like that, and you have a case where there's a search of a home and there's no consent given and there's no warrant, then you might really be able to have a good issue worth holding on there. But generally, with respect to houses, that's going to be the highest level of protection afforded when a warrant is, if a warrant doesn't exist, it's going to be real hard for the officers to get in there. And then, even if a warrant was issued, make sure you really get into the facts on that, because there's generally more facts than odor alone. I certainly have not seen a single case in my career where odor alone was enough to get a warrant. There's usually more that is required. So that's kind of those stop search issues. Obviously, I could spend days and days talking about stop and search issues, but I wanted to give you just these highlights on odor of marijuana because, again, we're going to come back in a few moments to how has hemp potentially altered the landscape of these types of cases. Before I get into identification, there's one other issue I was thinking about that I think dovetails nicely before identification, which is constructive and actual possession. Partly because this is a very, very common defense that you're going to have in marijuana cases, is whether your client was in possession of the marijuana at all, even if in fact it was marijuana. Let's assume the search is good, the drugs have come in. Can the state prove that your client was in possession of it? And one of the things I always like to remind people is that, the language is actually good for us in the jury instructions. I always encourage you to read jury instructions because that's what the jury is going to hear later. But read up on actual and constructive possession. One way I usually like to break it down for a jury is this, because I think there's a lot of misconceptions about what constructive possession is. I think people get told, and I understand why they get told, be careful who you hang out with because you could be on the hook for everything they do, and that's a good rule to remember, because legally or not, whether you're legally culpable or not, you should always be careful about what kind of trouble somebody else around you could get you into. But it is not legally correct that you are on the hook for everything that your friends do when your friends are around you. And so one way I like to explain actual and constructive possession to juries based on the jury instruction is we start with actual. So I actually possess this pen. Why? Because it's in my hand. I have knowledge of it. And clearly I'm demonstrating some intent to control its disposition or use. If I set this pen down, in fact, if I leave it here and walk out of the room, I am in constructive possession of that pen. Why? Because I have knowledge of it, element one, and I have both the power and intent to control its disposition or use, which is kind of multi-pronged, but generally just considered the other element. I know that the pen's in this room, even if I'm not in here, and I have a clearly demonstrated intent to continue to use it. It's my pen, and I'm going to keep using it. Let's take a step back. If I'm riding in a car with a friend, and the friend gets in the car, and the friend has on a nice pair of Nike Air Jordans that I notice, I'm not in constructive possession of those shoes just because they're in the car. In fact, they might be in my car on my friend's feet, and I have certainly got knowledge of his shoes being in my car. But I am not in constructive possession of those shoes because I do not have the intent to control the disposition or use of those shoes. So just swap that out with marijuana, okay? We're in a car. The marijuana is found in the center console. Let's even pretend, again, I'm the driver. I've got a friend in the passenger seat, a friend behind me, and a fourth friend who comes in, jumps in the car. We're all headed to the grocery store or something together. And the friend says, "Oh, by the way, I bought some weed today. Check this stuff out," and slaps it on the center console. And at that very moment, the police pull the driver over for a traffic infraction and seize the marijuana sitting there. Now, there may be probable cause to charge the driver who is sitting next to this weed in the center console, but that doesn't mean that there's evidence beyond a reasonable doubt that the driver is in possession of the marijuana. And the reason being is, if you believed these facts that I've set them up, if a jury accepted those facts, if we didn't get something else in there like that the driver said something about, "Oh, great, let's all go to my house and smoke this together," or something that would show that the driver was now exercising some intent to control the disposition or use of the marijuana without any additional facts, the driver is not in constructive possession just because a friend showed something to the driver. So there's fertile ground here, and perhaps more so than you think, on constructive possession cases for narcotics, firearms, things like that. Partially because it happens all the time that a person does something against the law, and innocent people who happen to be around get caught up in that. And so that's an important other area in defending marijuana cases, is just remember to keep in mind what the law is on constructive and actual possession, and read that jury instruction language. You'll find that it's a lot more helpful than you might know if you haven't read over it before. So let's talk about marijuana identification a little bit, because remember, the state has the burden of proof to show not only that your client knowingly possessed a controlled substance, but also that the substance itself is a controlled substance. And generally, the state proves that by putting on a chemical analyst, or they use an affidavit. There is a statute that allows you to object to them using an affidavit, so they actually have to get a chemical analyst who may or may not be available. So always be filing that objection, because why not have one other way to protect your client? I just throw the objection in my discovery requests, and it makes it super easy. If you're in district court, you can file the objection. Go ahead and get a Form 1 and file it every time. There's no reason not to be doing that. But normally, that's how the state proves that a controlled substance is a controlled substance, because if the state can't prove it, the case should be dismissed at the end of state's evidence. It shouldn't even go to a jury, or survive a defense motion to dismiss the charges. There are a few exceptions to needing a chemical analyst. A big one is called the Neighbors exception. That's State v. Neighbors. That's a situation where defense puts on evidence and they admit that the substance is whatever it is, because that may not be part of what their defense is. They may not be challenging the substance. They just may be challenging that, the defendant was actually the one who was possessing it. There's another incredible exception under a recent case, State v. Bridges, where the defendant stated that he had meth on him, and then the defense didn't put on any evidence. There was no chemical analyst. They just used that hearsay exception, a statement against a party opponent, and used that and said that's enough for it to survive a motion to dismiss and go to a jury. That's an incredible outcome. Certainly, you can conceive of how many times your client thought they had heroin and instead it was fentanyl. Even our clients are sometimes wrong about what they have. And that outcome seems kind of crazy. Now, that doesn't mean that your client's guilty. It just means that's sufficient evidence on the issue of identification, on the state's burden of proof that the substance is the substance, to go to a jury. So you could certainly argue that the weight of the evidence isn't there, even if there's enough to make it go to a jury. However, there's a great criminal School of Government Criminal Law blog article on that by Phil Dixon. I encourage you to read it. That case may not be as broad as it sounds. partly because, as Mr. Dixon points out, the opinion itself states that the defendant's statement came in without objection. Now, you and I might think, well, what is there to object to if it's admissible hearsay? It may be hearsay technically, but it's admissible as an exception because it's a statement against the defendant's interest or admission of a party opponent or whatever. What would the objection be? And he posits the argument that the objection might be that the defendant doesn't have the foundation to lay an expert testimony, which is what you need, expert opinion that a substance is a substance. So as long as, if you're ever in that situation, you object to it, the outcome might be different. Now, the biggest exception, which is why marijuana falls under a different category, is that marijuana, up until this point, does not require a chemical analysis because a court case named State v. Fletcher states that officers can testify as experts that marijuana is in fact marijuana based on visual inspection. So State v. Fletcher is a 1988 case that is sort of sets the stage for most of the ways that marijuana evidence comes in against your clients. And that is that these two officers testified. Between them, they'd had over a decade of experience. They had been trained specifically in identifying marijuana, and that the court lays out how we get to expert testimony, and it lays out a couple of different what the law was at that point about expert testimony. Specifically, is the testifying expert better equipped to give an opinion than your average layperson who might be on the jury about the existence of a fact, in this case whether this substance was in fact marijuana, and then the Court of Appeals noted that there wasn't much of an objection about what qualifications these officers may have had for the basis of providing this testimony. So there might be a little leeway just in the language there regarding whether officers can testify without a chemical analysis for marijuana. But up until this point, the landscape has been that they can provide expert testimony by visual inspection of marijuana, and that is enough to send the case to a jury to survive a motion to dismiss. The reason why, before I even talk about hemp, Fletcher can be on different grounds today is in the time between 1988 and now, there have been amendments to Rule 702, which is the analog to the federal 702, which is our expert testimony statute that covers that admissibility. We've made some reforms that have made us come more in line with what's called the Daubert standard. And so because of that, there is fertile ground for you to cross-examine officers on the basis of their expert opinion. And there's a lot of great articles about that. I could spend a whole hour talking to you about that. But that is a good area for you to consider that Fletcher may not be completely determinative of the way that marijuana evidence comes in, even before we talk about hemp, because there have been some amendments to the expert testimony rules. So that brings us to hemp, and what I'm showing you now on the screen is this is a memo that was authored by the North Carolina State Bureau of Investigation. So that is the organization within the government, the state government, that is in charge of testing of most of the controlled substances, and this is the lab that's generally going to send you your results back when you're representing a client who's charged with possession of a controlled substance. And this is it doesn't have a name that's signed to it, but the director is attached to it, and this letter was essentially addressed to the General Assembly in response to the proposed law that was being proposed to legitimize the hemp industry. Hemp cultivation was already legal because of the federal descheduling, but there was a proposed law in North Carolina to completely legitimize hemp. And so this memo was authored and sent to address some of the potential issues that may arise because of this. It begins with a little bit of an explanation of what hemp and marijuana are. It talks about CBD, which we've been talking about a lot. CBD, THC, these are all compounds found within marijuana or hemp plants. Of course, hemp has a low concentration of THC and a high concentration of CBD. This is cannabidiol oil, which people believe has health benefits. And this second page talks specifically about issues for law enforcement. And I will just read directly from it. There is no easy way for law enforcement to distinguish between industrial hemp and marijuana. There is currently no field test which distinguishes the difference. Hemp and marijuana look the same and have the same odor, both unburned and burned. That makes it impossible for law enforcement to use the appearance of marijuana or the odor of marijuana to develop probable cause for arrest, seizure of an item, or probable cause for a search warrant. It goes on to say that in order for law enforcement to seize an item to have it analyzed, the officer must have probable cause that the item seized is evidence of a crime, and in that, furthermore, in these upcoming confrontations and contact between law enforcement and the general citizenry, this is going to present a serious problem, both for the odor used as probable cause to perform a search or to make an arrest, and also for identification later in court. The memo mentions that there's at least one district attorney's office at the time this was authored that is no longer prosecuting marijuana cases because of the inability to distinguish the difference. And it also mentions that the North Carolina State Lab is not conducting testing to differentiate the difference. We know that there's no field test, but the lab itself is not conducting a test which would differentiate between the two. A lot of these tests can determine the presence of THC, which again is going to be in both hemp or marijuana, but it's not for the quantitative levels of THC, which would be the only way to determine the difference between hemp and marijuana. So with your SBI memo in hand, you can now challenge the expert opinion testimony of officers who are trying to give an expert opinion that a substance is in fact marijuana without a chemical analysis that we all know is too expensive for the state to get, and they're not going to get anyway because it's not worth their time. So if an officer tries to give an opinion, you make a 702, use the expert opinion rule, make a 702 objection, go through what the requirements of 702 are, challenge the officer's basis of knowledge for this, challenge the methods that they use to determine that this is marijuana. The officers are going to have to admit that they're simply not trained to tell the difference between marijuana and hemp because there is no way, because they don't have field tests to distinguish the difference. So make those challenges. You can do it if you want, you can even get an expert to help you make that challenge. If you want to put on an expert who can give an opinion about who has knowledge of the memo, you can certainly cross-examine the officer about whether he has knowledge of the memo, but you could get an expert. If it's an indigent client, you could get the state funds to pay for an expert. So you can really tie up a lot of resources and make this case not worth prosecuting for the government. I'll say one last thing about identification. Let's say you're in a situation where your client admits that it's marijuana. We don't always get the most ideal situations. That may, maybe it invokes one of these exceptions to the chemical analysis rule and it survives a motion to dismiss, but that doesn't mean that your client is guilty. It just means that now a jury has to decide. And if you ever want a good argument for why that may not be enough there. Remember this: we dealt with a whole situation where a bunch of people thought they had heroin or opium, and it turned out to be fentanyl. It happens all the time. We take our marijuana in a factory packaging, pull some of it out, nice little dime here, drop it in a bag, twist it off, and make a corner bag, and then sell this to someone because it's cheap and you can get one over on somebody by selling them hemp and telling them it's marijuana. It's certainly not that crazy that your client might be caught with this and not even know that it isn't marijuana. So never give up hope, never stop fighting. There is always something else. It's very possible your client simply doesn't know what it is they have. And without a chemical test, how can any of us know? So aside from identification, hemp also changes the landscape on probable cause. You can and now should be considering whether officers actually do have probable cause to search a vehicle or to make an arrest based on the smell, the odor of marijuana, or even the sight of marijuana. If there's no way to tell the difference, and it could be a completely legal substance, if all they're going on is sight or smell, you may have now a very useful probable cause motion or a suppression motion of some type, and that can be coupled with your challenge to the identification later if your motion to suppress fails. So this opens up a whole new ground. Now, the interesting thing about it becomes, well, what do we do next? So a lot of the law enforcement lobby has talked about, how there may be this need to start to, when you're looking for probable cause, to look for odor plus, and that may be where we're headed in. That may be the next landscape of marijuana cases that you're going to be handling, which is officers testifying, look, I smelled marijuana, but on top of that, I noticed that he was sluggish, or there was an open bag of Cheetos or whatever. But there's going to be odor plus some other type of evidence that may need to come in to hit that level of probable cause. So be on the lookout for that. Another thing to think about that may be the next standard in probable cause. But at this point, the best thing to do with these types of cases is to get out there, challenge them, start normalizing the idea that this is where PC cases should be headed, that odor alone should no longer satisfy this. And the state has essentially admitted that how can you get probable cause based on odor alone when it clearly could be something else? So I want to leave you with this, and I haven't really made much of a secret that I like to engage in movement lawyering when it's in the best interest of your client to do so. The late great congressman and civil rights hero John Lewis put it this way, and it inspired me a lot when I was a public defender, which is, it's our duty to get in the way. And you don't have to be a jerk about it. You don't have to make it personal to anybody on the other side of the courtroom. But it's our job to get in the way of systems like these that lead to bad outcomes. I mentioned this earlier. The data doesn't lie about the fact that among races of people, drug use, particularly marijuana, is roughly equal. So why is there a racially disparate impact in who is charged with marijuana, who ends up having these convictions, and most depressingly, in states where there are other places where they are taxing this stuff and making lots of money off it, and here we're still saddling often very poor individuals with lifelong convictions that are severely putting restraints on their ability to achieve. It's a bad system with very, very racially disparate outcomes that is not due always to some sinister person who's saying arrest these people and not these people, but it does have to do with implicit bias in where we choose to focus our resources on where we think marijuana is, and so we police in these areas, and this is how we lead to bad results. And the best way to fix that problem is you need to get in the way, and you need to challenge this and challenge it and challenge it, and become such a pain that they stop prosecuting these cases, because they shouldn't, because it's the right thing for us to end this practice to make a more just and equitable society. So, I hope I've encouraged you. Please get out there, do it respectfully. You can and should. But remember, you got into this fight to make better outcomes, and this is an area of law where there are very unequal outcomes that you simply can't deny from the data. And so, I'll see you next week. I've got a couple more tips for you, and we'll talk a little bit more about this issue of getting in the way again. But I hope you've enjoyed it, and happy fighting out there.